I'll just give a brief introduction, and then John, I'm assuming you're planning on sharing your screen then.
Yeah.
Okay. So welcome everyone to the PDHC webinar of how the law helps guide entrepreneurial science. We're joined today by John DeMeo from Hodgkin Russ. He's the intellectual property and technology practice where he focuses on preparation and the prosecution of patent applications, including peptides. So this presentation will be specific to, peptides, and we'll probably have a brief 20 minutes John presentation, and then we'll get into like a Q&A discussion that Charlie Johannes will lead, and focus a lot on some big questions regarding AI and how that and disclosures and how that works in our field.
Cool. Hi everyone. My name's John. Before I became a patent attorney, and I'll share my screen in a second. I did my PhD at the University of Rochester. Actually, when I was a graduate student, Phil Cistrone, who's on the call, was an undergraduate in the lab next to mine working for Rudy Fasson. I did my doctoral. Hey, Phil. I did my doctoral work with Brad Nilsson out of University of Rochester, working on peptide self-assembly and functionalizing self-assembling peptides to make biofunctional molecules. Let me pull up my presentation and then pull up Zoom if Zoom will share with me. And what we're going to do is you'll see just an email for the invite, and then we're going to see if I can get this working as I want it to.
So, John, you're not in Rochester anymore, right?
No,
Short.
I actually am.
Oh, you are.
Yeah,
Okay.
so the what ended up happening was I wasn't sure if I wanted to go to law school initially. And I was like, oh, if I don't like this, I'm going to be committing financial suicide. Um, so I ended up applying to University at Buffalo, which was just an hour away from Rochester. And being a state school, its tuition was cheaper. And that way, the thought process in my mind was it was like a postdoc I had to pay for. And if I hate it, I'll jump ship. And I ended up really, really enjoying it when I was right after I finished my first year, so during my second year, or transitioning to my second year in law school, I had ended up meeting who was the practice leader at the time. Or her name was Ranjana Kadle. She was a biologist by training. She was leading our group, and I had met up with her because I was working for University of Buffalo Tech Transfer, and they were looking for an organic chemist, and then they hired me when I was in law school, and I've been with the firm since then, since 2016. And Ranjana's background, like I said, she was a biologist, but she actually did some work with Hiroaki Suga when he was at UB as well. So some of Suga's earlier work, I think all those patents have since expired, was handled by my predecessor. And
Yeah.
now I lived in Buffalo for a while, and now I actually live just outside of Rochester, southeast in a little town called Farmington, because my wife is also an attorney here. So not at the firm, she's a prosecutor. So she likes to remind me on a daily basis that she's a real lawyer, and I am not, because
Right.
I don't go to court.
Yeah.
Uh, so. So today we're going to be talking about how does law help guide entrepreneurial science. I have a bunch of slides in here, and I'm just going to skip through most of them because some of them will be interesting, some won't. The first thing that I have to do, if anyone's ever sat through a legal presentation, every single legal presentation starts the same exact way, which I am an attorney, but I am not your attorney. Everything I say in here is for general informational purposes and in no way establishes a client-attorney relationship. And any views that I express are mine and solely mine and do not belong to that of the firm. So the things we're going to talk about today, or can talk about today, are patents, trademarks, copyrights, trade secrets, NDAs, and use of AI. I'm probably going to skip through copyrights because they're not very interesting and they're kind of boring, and only briefly touch on trademarks and trade secrets and NDAs because they all kind of end up coalescing with the whole concept of being an entrepreneur in science. Really quickly, just an introduction to the firm, to the group. So as Tommy alluded to, So I am out near Rochester, but our firm is based in Buffalo, New York, which is the second largest city in New York State. And we have offices all throughout the Eastern Seaboard. We have Florida, North or South Carolina, Toronto, New York City, and then all throughout New York State. So Albany, Saratoga Springs, two Rochester offices, and a Buffalo office. The firm is comprised of about 250 to 300 attorneys at this point. We do every type of law you could imagine, with the exception of maritime law. We once had a Japanese associate ask us if we practiced that, and that was the first time we've ever gotten a type of law that we didn't practice. But within that firm, we have a dedicated group of IP attorneys, and on the screen right now, these are just our patent attorneys that do exclusively patent preparation and prosecution. They also work on some trademark stuff and litigation, but the bread and butter of what they do is patent prep and pros, with the exception of Neil right here, who is a trademark attorney, and that's all he does. And every single person at the firm, or every single person in our group, has some sort of technical background, and we only work on inventions that fall within our discrete technological area. Lipinski he's a biologist. Al is an electrical engineer. I'm an organic chemist. Sam's a mechanical engineer. Nathaniel is an electrical engineer. Chris is electrical and mechanical. Charlie's mechanical. Kent is mechanical and electrical. George is mechanical, and Rachel's physics. So we do a wide range of everything you can imagine we can typically cover. Um, and my practice ranges from working with universities to large companies, small companies, on kind of everything in between. So there are four main types of IP. My main interest is on patents. Generally, getting a patent is very complicated. Um, they're very flexible because you can publicly disclose after you filed something, and you have the ability to sue others with it, because essentially what you're getting anytime you file a patent application is a limited monopoly with the government, which allows you to exclude others from making, using, or selling whatever you describe in the claims of your application, or issued patent rather. Trademarks, this is something that can use to identify a good. Obtaining them, it's kind of murky and difficult, but easily doable. It's nowhere near as complicated as patent prosecution. The burden is you have to use it, and everyone, no matter what room you're sitting in, is in a room that's littered with trademarks. They're readily used to identify whatever good or item that you're shopping for. Copyright, we've all dealt with copyrights, getting our doctorates, and publishing. These are generally not complicated. It's a matter of sending a check for $50 to the Library of Congress. Very simple, very easy to do. Trade secrets, also not complicated. It's just, can you keep a secret? Flexibility is really low because the whole point is keeping it a secret. And the ability to stop others outside of litigation, really, people can reverse engineer whatever you're protecting. If they reverse engineer it, that's fair game. However, if they steal it from you or go through some other means to get it, that's not good, and we're generally where you see secret litigation. In terms of patents, it's 20-year limited monopoly, as I said, that you get from the government. Prosecution is a long and arduous task. It can, from the moment you file something from a U.S. non-provisional, generally takes about 2 years to get an office action, which is the substantive start of patent prosecution, which is essentially your patent attorney arguing with the USPTO about why you deserve a patent. The USPTO employs about 8,000 examiners. Each of the examiners are, again, scientists and engineers, sometimes attorneys as well, but all people who have ordinary skill in the art or expert level skill in the art. And they are the people who do exactly what their name says. They examine the application and they argue with you about whether or not you deserve a patent. And the other thing about patents is they're jurisdictional. If you get a patent in the US, it only protects you in the US. If you want protection in China, India, Japan, you name a country, you have to file in that country. Generally, there is overlap in the process and procedure and the arguments you can make, but there are nuances that change in each jurisdiction. And so typically, when I'm working with a client that wants to file in Japan, we engage with local counsel, and then we work in tandem with the Japanese counsel and our client to, hopefully get them a patent. Why get it? And this is important really when you're, in the startup world, is when you're looking for investors and partners, building a strong portfolio can make you more attractive in terms of getting funds from investors. And you can actually use it as a cudgel to attack others who are going into your space. You can use them to send nasty grams. The downfall with filing a patent application is it costs money and it's highly complicated. But the nice part about getting a patent is that after you file a patent application and you want to disclose something like, say, publish a paper or go give a talk or a poster, you can present it, assuming everything that you want to present is covered within the context of that patent application. The other thing about patents, especially in the US, there's a little bit more leeway, but there is a disclosure deadline. In the US, you have 1 year from your date of disclosure to file a patent application. If you don't do that, all rights to that application are lost. Other jurisdictions are a bit more draconian, and you have no right after you've made a public disclosure. So oftentimes we have clients, they may have like a professor may have a paper that's about to publish, and we have to turn that into a patent application. And we have 1 day to do it. And so, we do it, but that way the paper can publish, and that way we don't risk losing foreign rights because oftentimes, especially with investors, you want to be able to get patents in both, especially in chemistry, at least the US and Europe. And if you disclose without filing patent application, or at least a provisional application, you risk you risk the ability to file in Europe, and that can be very, very detrimental because Europe's a huge market. Um, in terms of patent, what they require, it has to be useful, novel, non-obvious. We don't really have to talk about this. This is, if anyone's curious, we could talk about it later. Really, the main important part about a patent application is the claims, or a patent at the end of the day is the claim. The claim is essentially, it's like a deed. It says this is the metes and bounds. These are the metes and bounds of what you invented. In this instance, this is a claim I drafted several years ago to chemotherapeutic agent, where essentially this is the actual issued claim. So any compound that falls within this chemical genus, and where each one of these substituents, or each substituent, falls within the defined definitions down here. If a compound falls into that, a competitor could be infringing on our client's IP, and then we can in turn sue them. Typically, you don't want to go through litigation. You just want to get a license, some way to generate money for the company. Software, we're not going to worry about other patent issues. We don't need to talk about this. Infringement, I'm not going to talk about that. Like I said, this is kind of a general presentation that I use. Trademarks. Like I said, everyone in the room right now has some trademark, whether it's on their clothing, whether it's on their phone. And it's really a word, logo, phrase, anything you can use to identify a brand. Um, can be a color too. If I say Tiffany blue, most people that have seen the jewelry brand Tiffany's will know it's that pale blue color. Um, and why file a trademark? It's a way you can identify and protect your goods. Trademark infringement matters can be very lucrative. You can use it to prevent people from selling knockoffs of your brand, of your goods, of your kits, whatever you're selling. And like I said, when I said they can be lucrative, you can get mandatory treble damages. Treble means triple in this instance, so you can get a lot of damages and a loss in trademark litigation. As you become a brand, as your company grows, these are important to protect. Trademarks are graded on a level of distinctiveness, where more fanciful terms are, it's easier to get a trademark, depending on how fanciful or arbitrary your mark is relative to what you're actually doing. So if you think about PlayStation's a perfect example for descriptive marks. It's descriptive, it's describing what it is. PlayStation, something where you can play games. The next one above that is suggestive, Microsoft. It's a portmanteau for software for microcomputers. Arbitrary, Apple for computers, because that doesn't really make sense. Now we automatically think of it, but 40 years ago that wouldn't have necessarily been the case. And fanciful, Kodak for cameras. I picked that one because I'm near Rochester. Um, Steps to acquire a trademark is you start using it and you file with the USPTO. And then you just kind of keep monitoring and make sure no one is potentially using your mark. If anyone follows the news, oftentimes you see a lot of trademark cases involving Nintendo. They tend to be very protective of their mark. And this is always because they're afraid of dilution or things becoming generic. You often see it with, I'm sure some of the more senior people in the meeting will remember you don't call it a Xerox. You're photocopying something. You're not Xeroxing it. Google has the same problem. You're not Googling it, although that's kind of changing because you want to be able to protect your brand. If it becomes generic, you no longer have a right to it. We won't, discuss marking, copyrights. This is just a tangible form of expression. So you can think about this in terms of publications, white papers, painting, photographs, any form of art, book. That's typically what you use copyright for. Um, Oftentimes with where we kind of see it, where people see a lot of it is fair use when people use another person's copyright and do something transformative with it and they claim fair use. Kind of one of the quintessential cases goes back to using sampling of music. Trade secrets, most common one that people know is Coca-Cola. Coca-Cola is a trade secret. No one really quite knows. You can figure out what's in it, but more often than not, it's also the way in which you make it. So trade secrets are it's often a valuable way to protect things where what you're doing is very, very complicated and can't be easily reversed because they last in perpetuity. So as long as something maintains or stays a trade secret, it's protected. The second it leaks, it's not protected. Whereas with a patent, one of the trade-offs is the fact that you're getting a limited monopoly. We don't want to give people monopolies, but because we're giving you a monopoly, we're giving it to you for a specific amount of time. It's only 20 years. So they try to limit that. So that's kind of the trade-off. Usually where we see people using trade secrets, and it's in areas where you can't easily reverse engineer whatever you're trying to protect. Um, that's essentially what I was just talking about, and kind of the common example people may remember when the Coca-Cola instructions were stolen from an old employee, and they tried to sell them to Pepsi. Pepsi didn't want it and ended up reporting her to the FBI. She went to jail for 8 years. NDAs as employees, a lot of people are going to work with or work for people that may require you to file NDAs and confidentiality, at least when it comes to patent applications and patent prosecution, is very, very, very important, mainly because public disclosures can sink patent applications if they occur before a patent application is filed. This happens quite frequently in academia. Oftentimes, a student or a professor will give a talk. They'll mention something that they shouldn't have, or they'll put it on a poster. Not necessarily that they shouldn't have, but they're excited to do it. And they do it before the professor talks to the university's tech transfer office. And that can be a public disclosure. We see it a lot with ChemArchive and BioArchive. Someone gets very excited. They put a proof of their paper up there before it's published. That counts as a public disclosure. Anything where the public can readily access it counts as a public disclosure. Most places that are generating IP, or most employers will make their employees sign confidentiality agreements or at least sign some sort of intellectual property ownership agreement, which means that anything you invent while employed by that employer will then belong to the employer. Same thing happens at universities. If anyone has any patents from when they were in grad school or from teaching, they may be an inventor, but the university in turn owns the underlying IP, which isn't necessarily a bad thing because that means the university foots the cost of patent prosecution. And oftentimes, most universities have some sort of royalty split where if the technology gets licensed by a large manufacturer, or, in our case, some sort of chemical supplier, the inventor will get some money in return. The example that I like to think of is sometimes it's lucrative, sometimes it's not. When I was in grad school, my boss, Brad, the work to his disappointment, that he is most remembered for is his work with the Staudinger ligation when he was working for Ron Raines. And that was, I think, eventually licensed to Sigma. And he would get a check from Sigma every year for $11. And he was like, I don't want to cash this. He's like, it's $11. It's not worth it. And he would eventually get a lot of emails from Sigma going, hey, we need to balance our books. Cash the damn check. And so that's always kind of what I think of. But, it always depends on whatever you're doing because oftentimes universities, they're not in the market be able to make the things that they're protecting. So they often give, an option to the inventor that if the inventor wants to spin out, start their own company, that the inventor gets the first option to license the technology. Um, that ends up becoming very lucrative for people. I mean, there are many, 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 many people that we can all name that have done this exact thing and have gone off, while being in academia to also have successful companies on the side that, from IP that they generated when they were professors, that they licensed from the university. We don't need to touch on that. Next thing, AI. So this is kind of the new big thing, and this is where I think we're really going to spend quite a bit of time when in the question and answer session, because the if anyone's had the, and you may look at it this way, the displeasure of having to deal with an attorney, the answer you may have heard from them at some point when you ask them a question is, it depends. And I can guarantee that nearly everything that I say over the course of the next 30 minutes will be moot within the next 5 years, because the law is also incredibly slow at playing catch up with what's going on in reality. So the guidance that the USPTO has issued now may not be the same as it will be tomorrow. When I was, we have to keep up with whatever's happening in the law as part of our jobs. We have continuing learning education requirements, and this has always been a sticking point for us because this is constantly changing. In 2024, we had direct guidance as to what factors we could use to determine whether or not, someone was an inventor when they used IP, and then in I think November 28th, the new director of the USPTO, John Squires, completely changed that. And it only applied to one set of individuals and not another. And it goes back to a previous way in which we kind of looked at who qualifies as an inventor. And it's a much squishier thing to think about. So the big thing with any sort of invention that you're filing, and I think this is true across most jurisdictions. I can't speak to that necessarily, not being licensed in those jurisdictions, but at least in the US, AI can't be an inventor. There has to be some natural person assigned that invented the underlying subject matter of the application. So, and this is kind of where the tension is now because the concept of inventing something, when you think about like authors on a paper, it's pretty easy to assign who's been an author because they contributed in some way, and that contribution may have just been labor. They ran an assay, they synthesized the peptide, they ran some sort of experiment. Whereas in, the inventors on or the authors on a paper might not be the same as, if IP is generated from that paper, might not be the same as the inventors because inventorship requires what's called conception. And so someone has to conceive, and it's that aha moment is how the court looks at it. They have to be able to see the exact item as it's claimed to be an inventor. And inventorship is determined on a claim by claim basis. So you can have an application that's got 20 claims. Inventors A, B, and C can be inventors, and person C may have only contributed to claim three. As long as claim three is in the application, that person's an inventor. Um, but with AI, it becomes tricky because you can kind of foresee a situation where someone has an idea, they dump it into the AI, they get a compound out at the end of the day, and then they file a patent on that compound. And there's a tension is did that person actually invent that compound, or did the AI do it? Or did the person who trained the AI did it? And we're going to get more into that in the question, so I'll kind of leave that for now. Um, are inventions that utilize AI patent eligible? They certainly are. The way we look at AI and the way I use AI in my workflow is it's a tool. It's a useful tool, but it's a tool, and you need to really to effectively use it. You need to understand what it is, because not everything it gives you will be useful. Sometimes it'll be completely wrong. I had a client come up with he was a physician. He had a particular indication he wanted to treat. He knew what the upon what where the small molecule would act in the body. He typed it into Copilot, and he came to me with a molecule. He wasn't a chemist by training, and he said, "I want to patent this." And it was chemical nonsense because carbon had 5 bonds, nitrogen had 6 bonds. There was a hydrogen coming out of a bond. There was just an errant hydrogen just hanging out. And I told him that. I said, "There's nothing. This isn't real." And he goes, "Yeah, I know. I made it with AI." I'm like, "No, no, 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 no. Like physically impossible. And he like I kind of walked him through it and he said, well, why would the AI do that? And that's kind of one of those things where there a lot of people are touting what AI can and can't do, and it can do a lot. And in the next 3 years, it's going to be able to do a heck of a lot more than it can do now. But you always need to be able to whomever the user is that's inputting your prompt and the person who's analyzing the prompt, you need to understand what you're putting in and what you're getting out to actually determine if what's in there makes sense. And that certainly applies in the legal context when you're trying to utilize AI. Let's say you're training a model on on a series of compounds to figure out, you know, compounds that'll act on a specific mutated androgen receptor. You're going to put in a bunch of compounds that, work on it. The person at the end of the day, when they, analyze the data, you need to have some level of comprehension of what you're looking at to make sense of it. Um, and the contributions from AI, there needs to be a natural person involved. When you've got a single person that uses an AI, the question is, was what was invented clearly defined in the person's mind? If you've got joint inventors, there are these things that are called the Panu factors, which goes to it's a case from the Federal Circuit, which is one of the appellate courts in the United States. And you just look at, did a person contribute in a significant manner to the conception? And this is one of those stupid things that's in legalese, which is contribute to the claimed invention, make a contribution that is not insignificant, where they use a double negative. Judges will do stuff like this all the time. I don't understand why they do it, but they do that. And, did they use it in such a way where it explained more than, or did the individual that was using the AI do more than just explain concepts to the inventors or stuff like that? And again, it has to be linked to a natural person. And these are just examples from the USPTO that have kind of pinned that down. But for now, that's kind of where I want to leave it so we can go into the question and answer session. If anyone has any questions after this talk ends, if you Google my name, I am not the Republican congressman from New Jersey. Um, that's what I look like in my firm picture. And like I said, my name's John DeMaio. There's my phone number, there's my email. I try to be pretty responsive by email, usually within a couple hours. If it's more than a couple hours, it's within 24. But I guess let's get started on questions.
Thank you, John.
Yeah.
Yeah, thanks, John. That was great lead in, and thank you for that, kind of special ending with regards to AI, in particular on the inventorship. But I think there's a number of other aspects of our day-to-day use of that and how it involves with research. And so I have a series of questions just to let everybody else on the call know that I did send ahead of time, John, so that he had a little bit of a heads up. But we'll use them to frame, how we get into this discussion. So if you have a comment or a question related to that, please feel free to step in and we can discuss it in a little bit more detail. So the first question that I had was really, what are the most common legal or IP risks you see when scientists begin using generative AI tools in discovery workflows?
Yeah, so there are two. The first one is someone not using an enterprise AI model. That bites a lot of people. That's always a concern for us. Whenever you use any sort of public model, if you go to chatgpt.com or whatever OpenAI's website is to access it, it's really, you're publicly disclosing it, right? There's a concern about this, and no one really quite knows if it's a public disclosure, because any information that you give OpenAI can be in turn used to train the AI further, unless you're using some sort of enterprise model that locks down that information so it's not being trained and stored, in a location other than what you're aware of. So like we have, enterprise Copilot throughout the firm, and anything we put into that AI isn't used for training purposes. It's all kind of locked down. So the first concern is, are you using a public AI and effectively disclosing it to the AI company? And the other one is what I touched on earlier, is trusting AI more than you should. And every day AI gets better. Just watching using ChatGPT 3 or 4 up to, I think we're on 5.2 is what's in our enterprise model for Copilot. You can see the difference in how it rationalizes things and thinks about things. So the biggest issue is really determining what's coming out of it at the end of the day, if it's actually correct and if it's something that you can use. And a lot of those issues are, your output. It's kind of like I call it GI Joe theory, which is garbage in is garbage out. And if you put in a prompt that is less than good, you can get an output that is less than good. So that's kind of always the tension and the concern that you have to think about is, is the output real? Is it good? Am I wasting time here? Especially when in smaller startup space, time is money, you have limited runway. And, if you don't properly vet whatever your output is and you go on, for lack of a better term, a wild goose chase on an output that you didn't properly vet, you can waste more money than you needed to.
Yeah, no, I mean, I think part of it is really just, and you mentioned this during the talk a little bit about knowingly made or readily making available to the public. And so I
Yeah.
guess at what point does like using the tool cross into potentially disclosing proprietary information, independent,
No,
for example, of having an enterprise system? I think, for example, you can create projects, you can restrict that knowledge from being used in
yeah.
the AI. And is that sufficient enough, I guess, to kind of claim that it wasn't a disclosure?
That's usually sufficient. And the unfortunate part is we don't have a good answer or feel as to whether or not like the current meta, if you will, for how most practitioners are looking at it is that they don't want clients to put that information into like an AI that could be used to train because we don't know what's going to happen. It hasn't been really, as far as I know, it hasn't been litigated yet. And you never want to be a case of first impression, right? Because the last thing you want to do is tell your client, oh, that's fine. And then it eventually gets litigated and it's your case and you're the fool, you're left holding the bag. And, we don't know because it hasn't been litigated. And my preference is always to err on the side of caution. And generally speaking, most companies, most manufacturers that have AI models in-house, they're all enterprise models. So, you know, my suggestion to any potential inventor is do it at work. Don't do it don't take your work home and do it on your public at your public account. Do it on your work account. Things that, where there is some sort of legal instrument at play where you've got some sort of contract between you and whomever your provider is that explicitly, they're stating they're keeping it private. It's locked down. It's not, there's no way that it could be used to train other models.
Right.
Um, that's at least the way I think about it, and that's how I coach my clients. And that being said, too, a lot of because I work with a lot of universities, they're using a lot of just their own language models, right? Their own things that they're creating in-house in lab. So everything tends to be proprietary. So it's become less of an issue. And at least in academia, it's less an issue. But the second we see people are using AI, we always inherently get leery as well because we always want to vet it as well, right? Like we don't want to wait. I don't want to waste a client's money, right? That's as a lawyer, that's the worst thing I can do because, if I waste your money on something superfluous, why would you come back to me for work? Because I'm frankly in the service industry.
Yeah.
I'm an expensive waiter, is how I look at it.
Perfect. So the next, I guess, topic was already, sort of discussed in your intro here, in your presentation, which is really about if AI is contributing to the design of molecules or, peptide sequences. How should companies approach, sort of the inventorship, patentability, ownership of resulting IP? So we'll skip over that a little
Yeah.
bit, since you already covered that. But many AI systems, as we all know, especially because of the advent of AlphaFolds, can really generate peptide or mini protein designs, depending on your lens, right? That look promising computationally, but turn out, and you've used the perfect example of a carbon bond with five bonds to it, which is impossible.
Yeah.
But maybe some things that are difficult to synthesize or fold experimentally. Hey, sorry, I have dogs
No,
in
you're
my
fine.
Hey, no, no, no. Yeah, no, you're not. Yeah. I'm house sitting for a number of dogs. Sorry. Um, So they're difficult to synthesize or fold experimentally, and so I guess from a patent perspective, how important is the experimental synthesis and the validation and strengthening claims around those molecules? I mean,
Yeah.
yeah, we need to maybe there's separate patents on inventorship there in terms of the synthesis as well as other isolation or purification techniques.
Yeah, so this is a very interesting question because I was having this conversation this morning with one of my colleague Al, and he's usually anytime I have like a legitimate like AI question, like how is this working? Like what's the computer theory behind this? He's usually the person I go to, um, because so the USPTO in February of 2024 put out pretty clear guidance about like they had this phenomenal example where they were talking about they had someone who made an AI, trained the AI, and then they had a researcher and their postdoc who then further used the AI and they dumped in a bunch of molecules and then synthetically worked on the molecules afterwards, made further derivatizations, took one of those derivatives and then dumped it back into the AI to get another compound out. And at the time, they had this very good layout about who was an inventor, who wasn't an inventor. And then Director Squires in 2025 just rescinded the entire analysis. And it's hard to tell if he rescinded it in its entirety or whether he just rescinded the fact that that it wasn't applicable to sole inventors, which I think it could have been. Um, it's it's one of those things where we don't really know yet, and any answer I give you now is probably going to change very quickly because the way I anticipate this happening is more often than not, um, and at least more like the way we've kind of seen, or the way I see patent prosecution play out is whenever we're going after a small molecule peptide, it doesn't matter whatever your target drug, we're just going to call it a drug, whatever your target of drug of choice is, you always have a particular indication that you want to use it on. Um, and oftentimes, what we'll do when we're drafting the application is we'll draft claims towards the composition and then claims towards the method of use. And you can sometimes get the composition, but the method of use will be much narrower. And the reason the method of use will be narrower, let's say it's a cancer drug, right? And you're saying you can treat cancer. And then you say it can treat, breast cancer. And then you have data saying you can treat breast cancer. You will probably get the claim saying you can treat breast cancer, but not cancers broadly, because you have data showing that you can treat breast cancer. And so from a patenting perspective, always having some level of data, whether it's in silico, in vitro, in vivo, helps us because we can then establish what's called enablement to the examiner. Um, but it gives you the ability to not waste money because filing patent applications, it's expensive. So usually at some point, I have very, very rarely filed a patent application where there is not some sort of wet analysis being performed, where they at least have made one compound that falls into a genus or one peptide that falls into a genus. Um, and the way I think it's being viewed now is that inevitably you have the idea in your head and then of what you want it to treat. The AI gives you, because you're to a certain extent, you have to define the parameters to get what you're expecting. And then you're going to experimentally validate it. And I think the way that it's been being, or at least it's being viewed now, is that experimental validation is enough, or it's that extra significant step. The question that I was talking to Al was, okay, what if you take a known model and it spits something out? Because you could argue that, and this goes to the point I was making earlier, where you need someone to vet what your output is to make sure it makes complete sense. When you've got that compound that doesn't make sense, like okay, well, I can't do anything with that, right? And so that could be that significant contribution is the recognition of what's important. Where it's going to start getting more complicated is that as we start having assays that determine efficacy you can just automate it, right? By doing some sort of high throughput assay, eventually you just get to a point where you're like, okay, anything that's above this threshold, we conceive will be good. And so the way I see this playing out is it doesn't matter what I think or what what we think will realistically happen. I think there is enough money in big pharma that lobbyists will bring this to Congress and hopefully address it beforehand because I think the legal community and frankly every chemist, we would be fools not to think that Pfizer, Amgen, pick your poison, they are not using large scale AI to make compounds and then validate those compounds. They have enough money and enough push where they can lobby and get legislation that won't let them leave a compound on a table, right? Because that would be the concern is they want to, that's the whole point of a company, right? It's so, excuse me, its sole fiduciary duty to its stakeholders is to give them money. And so they are not going to leave something on the table that could make them millions and millions and millions of dollars or billions and billions of, it's kind of inconceivable. And so that's the way I think it's going to go. Um, which is a really bad answer because it doesn't necessarily answer the question now, but we don't know because it hasn't been litigated. Really, the only thing that they've been clear on is there has to be some sort of significant human contribution and that AI is a tool and we're using it as a tool. That's really where they've kind of left it until we start seeing cases where the Federal Circuit, which is the first appeals court outside of the PTO that handles any sort of appeal on a patent case, they're going to be the first kind of real test for it, and then we'll see whether or not the Supreme Court picks it up. And anytime the Supreme Court picks up a patent case, they usually mess up the entire field for 10 years, and we're all left there like holding the bag, scratching our heads. And you've got a bunch of, and I hate to say it this way, but a bunch of poli-sci majors talking about cDNA. Like, are they the people that are most qualified to be talking about cDNA? Probably not, but that's how our legal system works.
Right. I mean, I think, I guess related to all of this is really that these AI systems can really generate a large number of peptide variants. And actually, the peptide kind of chemical space is just enormous,
Yeah.
especially when you consider non-canonical, kind of components to that. And so I guess from a patent strategy standpoint, because you can only make so many of them, and you need to enable that, and you need to synthesize some of them to show that. And then, of course, if you don't test them all, then you don't really know about the unobviousness of the biological impact of that. So what is your kind of feeling about how you claim a patent, how you draft that, and then what is your, I guess, confidence on that actually holding up down the road when, a lot of drugs, like particularly natural product space,
Yeah.
there's a really close analog that actually, overcomes something that was unobvious.
Yeah. So well, first off, hindsight's always 2020. Anytime because anytime you draft something guaranteed, every practitioner I've ever spoken to right after they're filed, like, oh, I wish I added this one thing to this application. A lot of it depends on like the threshold question I ask every inventor is what do they reasonably believe? Because when it comes to peptide synthesis, when it comes to organic synthesis, there are, obviously you can't make, the 1 million different, like if I take a genus claim of a peptide, right, where I say let's say you've got 10 amino acid residues, you lock in six of them, and there are four that are variable. And then you say those four variables can be any one of the 20 canonical amino acids. Okay, that's going up factorially each time you add a new variable in. You can't make all of them, but you can reasonably believe that a certain subset of them will work based on the data you have. And so that's the argument we always make. So I try very hard when we try to pull this out from inventors, because we know there are certain residues that won't matter, and there are certain residues that we know do matter. And then, it's kind of the same thing when you're, looking at any sort of experiment. Okay, what if I turn this phenylalanine to like a cyclohexylalanine, right? Like remove all the aromaticity. What if I turn this leucine to an isoleucine, something like that? There are certain conserved mutations you could probably make in the patent application and get away with it. And oftentimes, when it comes to the composition of matter, you don't have to have made everything. The threshold question is if you've made a bunch of them, you can probably get a fairly large genus. Where you will start to see difficulty is if you start getting into an argument with the exam, and this is where it's always hard in the peptide space because almost always you claim a peptide and you draft the peptide having some points of variability, or you say it's a protein comprising at least this sequence, right? So the protein is part, or the segment you're concerned about is part of a larger protein. You always try to throw in the claim some level of identity, or any protein having at least, I try to throw in 75% identity, and you'll never get that. Like, yeah, like the closest I've ever gotten is I got 85% once, and I was surprised. I was like, I can't believe I got this. But you throw it in there, and you can usually get around 90 and 95. And there are arguments you can make is that you expect most of these mutations are conservative enough where you don't think they'll have that much of effect and they would still work. And, they make sense within the frame of what you've actually invented, right? Um, when it comes to the method of use, that's where stuff gets tricky. There was a case 2021, 2022, which was Amgen versus Sanofi. And in that case, what they were looking at was they were claiming antibodies. And the way they had claimed it was they had claimed it functionally. So rather than claim whatever the sequence was, they claimed it about how it binded to a specific substrate. And the problem with doing it that way is the court said, well, you only had 37 examples, and you've told anyone that it's anything that combined to this particular substrate. You haven't enabled all that because you've only shown 37, and you've put all the work on a potential infringer because now they have to unduly experiment to figure out what actually falls within the metes and bounds of this claim. And that made sense as a patent prosecutor, like, okay, I can understand what's going on there. But the way the USPTO because anytime the Supreme Court comes up with a ruling, the USPTO will interpret it in a way that upsets every single patent prosecutor. Like, why did you interpret it that way? That was the worst way you could interpret it. And so what they've essentially done with that is when it comes to like method of use claims, so when you're taking your composition and you're using it to treat some sort of indication, we think about in the patent world, we think about indications as like a series of genuses and subgenuses and then individual species of diseases, right? So you think about cancers as your genus, and then hematological cancer as your subgenus, leukemia as your species. And then that can even further break down to different types of leukemia, right? So you've got these different orders. You might not get that broad genus of cancer, but you could get that subgenus of hematological cancers because you have data spread across, different cell types or different types of cancers. Now, where that can further twist is that you might not get a method claim that covers everything in your composition of matter genus. You might get a smaller subset that is closer to the data you actually have. And that's what's been happening now. I don't know how the USPTO is going to start interpreting, um, because the argument that I can foresee making, and I would love to have an inventor be able to provide this for me, is be able to dump, well, okay, well, we tested this in an AI with these different element, this genus, across the cell line, across this, and this is how we anticipate it would go. And because what we can do during prosecution is we can present additional data that's been obtained after the application has been filed. It's presented in what's called a 132 declaration, which is just an expert declaration. And we can present those data and use that as an argument to the examiner to argue what we would say is indicia of non-obviousness, so some sort of unexpected result. We'll look at what it's doing. This is supporting our claim. And I haven't been in the opportunity where I've been able to do that yet, and I have no idea how an examiner would interpret that because I think there are like most scientists that I've spoken to, and this was always what we would say in grad school. The computational chemists never trust the wet chemists, and the wet chemists never trust the computational chemists, right? Like they just disagree all the time. And I think to a certain degree, there has been a lot of that same bias that still holds true, where experimentalists trust AI to a certain extent and are not comfortable with, an AI saying, well, it could work, right? They want to in turn validate it by having some sort of wet chemistry to do it. And so I think that a lot of examiners at this stage would probably feel the same way. This is just a guess until there's some sort of further guidance. Um, but it's one of those things where, it's a tool, you use it and you hope and you see what you hope and you try.
Right, right. Yeah, well, I have more questions along this line. I just
Yeah.
wanted to pause here real quickly since we have only 7 minutes left to see if anybody on the call at the moment has a question that they'd like to ask instead.
Yeah, I have a not such a simple question, but I think it's a strategic question, John.
Yeah.
And when you're guiding those that you're working with in terms of what they file, what they include, how many examples they have, um, and you get a sense of of what they have, looking across at yourself. Sometimes, the at least the chemists are, still making compounds. So, it's a continuous process. And
Yeah.
and so the question is what you file, and then it creating prior art against yourself. And do you ever kind of have to guide um, your strategy with whoever you're working with to
Yes.
make sure that you know what's maybe forthcoming so that you don't make prior art against yourself, So
Every day.
yeah, yeah.
That
That's challenging, right?
it is very hard. Because so at any given time, I'm prosecuting a couple hundred cases. And so I have to keep the chemistry for a couple hundred, different inventions kicking around at some level in my brain. And usually, like, I do it by taking a lot of comprehensive notes. And when you're working with, serial inventors who file a lot, you are always kind of combating, you know, there's that tension. Okay, how much can I include now? What data do you actually have? Because you try to find that reasonable point of here's what they have, here's what they think they're going to make in the next year if you're going to file a provisional application. And you draft the provisional assuming they can get everything you want within that first year, right? Because then you can incorporate it into the non-provisional or PCT, whatever you're going to file, and not worry about creating new matter. Um, and if you don't have a disclosure or you're not worried about a competitor in that first year and you don't hit those milestones, it's great because what you can do is expressly abandon that provisional, refile, and restart that 1 year timer. Of course, the problem is you don't know what else has been filed because things don't get published for 18 months until after they're initially filed. And you're always combating with there's a potential competitor out there that you don't know exists. So the first tension is figuring out how much do you think the inventor can reasonably do in a year? And then that next turns into, well, what's your research plan going to look like for the next couple of years? And sometimes when we see like what's an obvious split, like I recently had this on a small molecule case where they really had two divergent like chemical skeletons. And I was like, let's just break these apart and file them at different times because there's no sense in keeping them together because your research project is going to focus on one skeleton versus the other. That's the dream situation because there's an easy dividing line. You
Mhm.
often don't have that. And so a lot of the time it's just trying to figure out from the inventor, like, what do you think you can get in a year? And if, you end up oversharing in the provisional, what you do is you hope down the line that you have enough support for what they do in the future that you can then file what's called a continuation in part, where you can actually get additional data. That's at least how I use them, is I'll add additional data rather than new like structural elements to whatever they're inventing. And you don't have to worry about losing your priority date because the worst thing you can do is argue against yourself because
Yeah.
then you usually have to say something that diminishes the quality of what you filed earlier. And we call that what's called prosecution history estoppel. And what's going to happen is some jerk litigator in 10 years, when the case is getting litigated, they're going to find what you said because it's going to be saved on the USPTO database in what's called Patent Center in the file wrapper. They're going to use it against you, right? They're going to say, well, you said on the record that it can't do this, right? And you're like, oh, crap. And when you're dealing with something about yourself, that's the last thing you want to do. So that's the constant tension. It's very, very, very hard. And a lot of the time, especially in the peptide space, I have one inventor that's a peptide guy, and he's always working with sequences that are kind of close, kind of not. So I'm always trying to keep in mind everything else he's previously done. And oftentimes what I do is I include a section of his previous work where I like will just put straight up provisos saying the peptide is not this, the peptide is not this, the peptide is not this. And that's a valid thing you can do in the US. You can do it in other jurisdictions. And usually when you're going against yourself, right? That's how you can carve out IP. Other times, the other strategy is I work with a guy who does a lot of liposomes. He has a very, very strong foundational IP that covers most of what he's been working on since. And a lot of his changes end up becoming in, modifications he's making to it that are still covered by the earlier IP. So he starts getting like these much smaller, narrower methods of use relative to the composition of matter. So there's always some sort of tension. There's always some sort of thing to a certain extent you're giving up. Um, and a lot of the time, you're trying to play clairvoyant and hoping you're doing the best you can. And if I was a true clairvoyant, this would not be my job. I would have been playing the lottery, I'd be gambling, and I'd be like sitting on a beach sipping a Mai Tai, not stressing about whether, it's hard. A lot of it is educated guesses and based on what they've previously done and their reasonable expectation.
I have to jump off here,
Yeah.
but it was great listening to you, John, and we'll be talking more for sure.
Oh yeah, it was great. It was great seeing you, Tommy.
Yep. Bye. Bye,
Yeah.
everyone.
Bye.
I think if there's anybody else with some questions, we can probably take one more before we run out of time here.
And I can stay on a little bit longer too if people have more questions.
It looks like everyone's being silenced. They're getting the answers they need. So this was a fantastic conversation, John. I definitely have a number of other things I'd like to follow up with based on this conversation. I'm sure other people will too. So thank you very much for doing this for us at the Peptide Drug Hunting Consortium. And
Yeah.
I'm sure we'll have an opportunity to host one of these again, maybe a little bit more specific on some of the topics we raised today.
Yeah, yeah. And like I said, if anyone has any questions or they want to follow up, please don't hesitate to email me. You can find me on LinkedIn as well. I know, Phil, we're connected, but we also go back like 15 years at this point, which is really crazy to think about.
For sure, yeah. I'll just reach out to you separately about
Yeah,
I have some macrocycle specific questions. We'll talk about them.
yeah, just shoot me a
Yeah.
text. You have my number.
Cool. Yeah. Thanks, John.
Cool. Yeah, no problem.
Great. Okay. I guess we'll wrap it up for today. Thank you very much, John.
Cool. Thank you. It was great
Thank
seeing
you,
everyone.
everyone.
Thanks, John.
Thank you.
Thank you.
Great session.
Bye.